wisdom from above to direct and guide us in all our consultations. And grant that we, having thy fear always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsel may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace, and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
Just before I begin, I want to just continue my comment on the difficult times in which the country finds itself, and the world continues to struggle in an effort to contain the COVID-19 virus. Thank God, Jamaica, through the diligence of policy and the diligence of the members of the health services, we have managed to operate in a circumstance that is not as bad as it could be. So as usual, we recognize all our doctors, nurses, all the members of persons, and particularly the persons who have a great admiration for the persons who do the identification and tracing. I think that's the word that is used. So we continue as a Senate to recognize their work. And of course, the diligence of policy, because without appropriate policies, the country cannot deal with this crisis. More specifically at home, we thank the members of the staff of the Senate who continue to come and support the work of the Senate on a weekly basis. And I noticed quite a few members of the ministry who are here to support the presentation of the legislation today. And we thank you for coming, notwithstanding the difficulties that the country and yourself are facing personally. I don't expect that the meeting today will be exceptionally long, but if it is that you all need a break, do not hesitate to just indicate to the clerk, and I will ensure that that is offered. And a special thanks to Senator Brown's daughter, who made this lovely bandana. I don't know if it's done on a commercial basis, but if it is, I would certainly recommend it. Oh, this is mine. Thank you very much. Please convey my gratitude. And it's lovely. Thank you very much, Senator Brown. Statements by ministers. Announcements.
Statements by minister. I thought there would be one today. Given that the government, you just spoke about policies, and the government has introduced a new policy, control re-entry. And I would have thought with a 64 million bill, and given the fact that 3 cabinet ministers apologized for some events, including, I think, my friend, Minister Samuda, yesterday, and the Prime Minister, that would get a statement giving us a sense. And having regard for so many Jamaicans outside who want to come in and may not be able to come in, we would have hoped that we would get a statement. If one is not available today, can we be promised one soon? Because people are calling us and asking us as Senator about the situation, and we believe the country needs an update.
Thank you, Senator Brown. Minister, you may or may not wish to respond at this time.
Thank you, Mr. President. Mr. President, a statement was not planned for today, but one will be made in short order. And I do understand the request made.
Thank you very much. Announcements.
laid on the table of the
Curtis,
Senate today
remember,
are the
my
following.
thing.
Ministry papers numbers 18 through 23. Cabinet agenda issues dated 2020, January 6, 13, 20, 22 and 27. First, Jamaica First Supplementary Estimates 2020-2021. Jamaica Public Bodies Revised Estimates of Revenue and Expenditure for the year ending March 2021. Annual Report and Audited Financial Statements of the National Housing Trust for the year 2018-2019. Annual Report and Audited Financial Statements of the Jamaica Social Investment Fund for the year 2018-2019. Special Report of the Standing Orders Committee of the Senate regarding proposed amendments to the standing orders to empower committees to hold virtual sittings.
Thank you very much, Madam. Bills brought from the Honourable House of Representatives, petitions, papers, reports from committees.
Mr.
Okay, so you'll take it at public business, I assume. Thank you, Senator Gale. Motions, notices of motions given orally.
Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following motion. Be it resolved that the special report of the Standing Orders Committee of the Senate regarding proposed amendments to the standing orders to empower committees to hold virtual sittings, which was laid on the table on the Senate on the 15th day of May 2020, be adopted. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion.
Thank you very much, Senator Gale. Questions and answers to questions? One minute, please. Ms. Vicaire. Thank you. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without the leave of the Senate first obtained. Public business. Minister.
Thank you, Mr. President. Mr. President, it is intended today to continue, or rather to close the debate on the Registration of Titles, Cadastral Mapping and Tenure Clarification Special Provisions Amendment Act, which we, of course, will refer to as the SPA, as we have been, as well as the Registration of Titles Amendment Act, both named as 2020 bills. I want to once more thank members of the Senate who participated in the debate and who really made substantive contributions to the considerations before us. The comments have been considered by the technical team, and several of them have been taken on board, so it's proposed to just go through them now broadly before entering into committee, so that where the issues have been addressed, then it might reduce the time spent in committee on matters which could otherwise have arisen.
Sorry, can I ask a question?
Yes, Mr.
We have two amendment sheets from last week. There are two amendment sheets that have been presented this week.
Yes.
Are they substantially different from last week?
No, Mr. President.
Are they exactly the same thing?
No, they are not the same,
Okay.
Mr. President. So I would have indicated. Yes, Mr. President. So both, there are two Lists of amendments which have been circulated this morning, one in respect of each bill. They are largely the same, but they're both were circulated, although they were not circulated at the same time, so they might not be beside each other in your pile. Yes. If someone could just assist. All right, okay. What I can indicate, though, or what I would like to indicate, is that on the list of amendments moved in respect of the RTA, there are just two small adjustments that I will make. Let me indicate now so that you can read them while I'm speaking. In paragraph D, under the amendment to clause 4, paragraph D, that starts proof of payment of property tax, instead of the words payment is, the payment is should be deleted. That's in the first line of paragraph D, and replaced with the words notice of the application is. So it will read proof of payment of property tax after notice of the application is advertised. And under the clause column, instead of clause 12, the reference there should be to clause 11. So those two small adjustments there. Otherwise, the amendments will follow as set out. Thank you. Mr. President, the issue was raised about land settlements generally, and this falls under the one of the legacy issues referred to in the opening of the debate, where titles have long been delayed for several different reasons, for various reasons. But two of the most fundamental ways in which these matters will be addressed are to be found in Clause 5 of the SPA and the proposed amendment of Section 7C3, which relate to the exemptions regarding planning approvals, the exemptions from transfer tax and other costs. So I will only give a gentle reminder that the process of systemic registration will allow for giving credence to on-the-ground occupancy conditions and for communities to give evidence about the occupation and possession of the land, so that the huge hurdle of having documentation to support a claim in title is going to be removed, and the community will have a voice, and that will be close a large gap that has existed in generational deficiencies in having asserting the right to family land. So this will work together, and of course that is always has a proviso that there's consent between landowners to adjust boundaries as well, because it's about the underground occupancy conditions. But also the amendment to the Limitation of Actions Act, which is set out in Clause 14 of the RT Amendment Bill, which again is taking us out of the realm of always having a document in writing. So again, making the issue one which is relevant and contextually appropriate for us, historically appropriate for Jamaica. And this will be supported by the work of the Adjudication Committee, again helping to give voice and cogency to claims for interest in lands that were traditionally undermined by the statute of frauds and the limitations. The issue of bauxite lands is one that I won't go into in depth, but simply to say that that is a matter of obligation, of responsibility of the bauxite companies. It is they who are responsible to deliver titles to persons who have been relocated as a result of mining. But the Commissioner of Lands has already commenced engagement with the companies to sensitize them to these new processes that they can now use to deliver title more efficiently and more quickly. So that once the bills are passed, that engagement can be enhanced to ensure that they actually are using the process. And certainly the voices of advocates who support and press for the rights of persons who feel they have been prejudiced can be strengthened now by having these processes available. A question was raised, Mr. President, also about the role of land surveyors. So I would simply direct the Senate's attention to the new proposed Section 9E of the SPA, which sets out the functions of land surveyors. Paragraph C provides for the surveyor to adjust boundaries of any land in the adjudication section or reallot same with the consent of affected owners. So that's quite an important role. And then paragraph E provides for surveyors to make declarations of existing rights of way over any land in a systemic adjudication area. And they may also direct the manner in which such rights may be recorded in the adjudication record in respect of the dominant and servient lands. Mr. President, not presented in the debate, Senator Sinclair had made a few suggestions which had been considered by the technical team. He didn't present last week, but one of them was to ensure that under the SPA, summons are served personally on applicants so that where they are to give evidence, there is no uncertainty about their awareness of the issues, and people can't have their interests prejudiced by a failure to be aware of the process. So that has been taken, has been accepted positively, and it is in the list of amendments for the SPA. And similarly, he had also suggested that the matter of obeying the summons be emphasized, and this is being done by specifying that the penalty to impose on someone who fails to obey the summons, because you may need to rely on someone in the community to give evidence of your family's right. And if that person, for whatever reason, just simply doesn't decide to show, your right, your ability to assert your right is prejudiced. So there must be some enforcement of that. And that is now to be imposed under 7B, again, of the SPA, which will provide for conviction on failure to obey and the imposition, of course, of a fine of up to $1 million. That is set out in the list of amendments. Mr. President, there was a question asked about there being a duplication under Section 5, and Section 7C3. But there is no actual duplication. So Section 5, the exemptions accrue when the minister declares a project area, and that's initiated by an application of an individual. And this is the process that's normally referred to as, or administratively referred to as voluntary approach to titling. Whereas under the new reservation or carve-out in 7C3, it seeks to ensure that once an area is recommended by the CEO of the NLA and then declared by the minister, so this is now a planning process where you've looked at an area and decided, not as an individual, but as you're now, as part of a planning process, you have recommended that a systematic adjudication area be declared. The exemptions automatically apply. So there is you won't need to now individually apply for the exemptions in respect of each parcel, etc., to ministers and other stakeholders, because that will automatically attach now under 7C3. So it's an enhancement of the process, ensuring that 5, which still exists, that's a voluntary process where an individual applies, that all of the exemptions will automatically apply when a planning process is engaged to declare an area once the minister has declared it. So this will ensure greater efficiency and speed of processing of titling. In respect of the adjudication committee, there was a question raised about its powers and whether it was it would be prejudiced in any way. The process has been streamlined, Mr. President. It's been clarified and it's been made more efficient. Small matters that cause huge delays, like the ability to appoint a chairman in the absence of the chair showing up, that will make a big difference going forward. But no changes have been made to vary the existing functions or the authority of the adjudication committee, and there will be no prejudice brought to any decisions previously made. They continue as a result of the provisions before us. And related to this point, Mr. President, there is no need for a transitional clause, which was also queried last week, given that the bills are designed to integrate the functions of the former LAMP program under the NLA, as well as to integrate the protocol for the efficient issuance of titles under the Registration of Titles Act and under the SPA. So the work previously done by LAMP is being done by the NLA. And as previously noted, there's no change in the existing functions and work of the Adjudication Committee. So the bills are streamlining the process, but they are not creating a new body. And accordingly, there's no need for transition. They're just administratively being made more efficient, and that being legally recognized through the bills before us. Mr. President, the issue of bona vacantia was also raised as a concern last week. And so I just want to address that a little bit. So clause 9A1B, 9 big A1B, relates to the land being designated as Crown land, being held in trust in circumstances where a determination cannot be made to issue title. And concern was raised about this. But, Mr. President, the designation of Crown land is a last resort where no evidence exists to support that there are rights existing in or over the land, so that there are no rights which meet any threshold amounting to ownership. So no rights even amounting to qualified title. And so that means that there's no reason to not have it be deemed to be bona vacantia. Remember that the Adjudication Committee, Mr. President, is going to be, it's chaired by a lawyer, it's inclusive, it will include community representation, and the committee will review the evidence that's presented and adjudicate. And the evidence can include oral recounts, it can be communal knowledge. So if even through all of that, so not requiring an old statute of frauds where nobody has a piece of paper, but everybody can come to the table to assert rights. Even with all of that, you cannot even get qualified title, then there's no evidence of sufficient relationship with the land to be protected. And the fact is that holding the land in trust, as provided for, Mr. President, will not preclude the applicant going to court and summoning the Director of Adjudication Services to appear before a judge. This is provided for in 9G. And so again, there's sufficient balance in the process to ensure that where an applicant really just cannot assert any right, that it justifies taking action. In this context also, it was felt that there wouldn't be any need to create any body corporate or corporation sole for these purposes, Mr. President. Mr. President, just to remind that the Adjudication Committee will apply established legal principles, and the utility of the SPA bill regarding evidence is going to be the prominence and weight accorded to communal and unwritten evidence, capable of corroboration from the very same community members on whom they would have relied. And accordingly, the technical team is confident that the balance struck by the bills is sufficient to protect the rights of persons who have a legitimate claim to land. Mr. President, in respect of the matter of the proposal for the Adjudication Committee to give written reasons for refusal, this has also been agreed to, and this is reflected in the amendment made to Clause 9 as related to the proposed Section 9 big G. So the Director of Adjudication Services will be required to communicate to the applicant in writing the decision of the director on the matter. This is again to ensure clarity, and of course if a person needs to get advice, get guidance, he won't be relying on memory or personal notes to try to explain why he or she needs assistance. There'll be a decision that can be reviewed, and that gives, of course, also additional support and certainty and fairness to the process. So, Mr. President, that's another enhancement that has come in these discussions. Mr. President, there was a suggestion made that the registrar, that the bill should actually outline set out the conditions under which a registrar could issue qualified title. But this was found not to be aligned with the policy of increasing facility and access, because you would in fact constrain the registrar, and the process now provides sufficiently wide latitude that it will cover any amount of circumstances under which a legitimate application can be made based on what an applicant believes legitimately grounds his or her interests. And this will be balanced by a large body of real property law and case law, which will help in identifying interests. So it was felt that to stipulate would actually narrow and not create an appropriate balance of certainty. And therefore that amendment is not being taken on board. Mr. President, in respect of property tax, a suggestion was made that the requirement for property tax to be paid on these applications be waived. But Mr. President, this proposal has not been taken on board, and this is because of the fundamental nature of how tax aligns with possession to help in being one of the indicators of ownership in a claim. So for an applicant to rely on their right and possession without the obligation of paying taxes, which applies to everyone else who establishes their legitimate right to property, it was felt that the better balance is as has been provided for, which is that title can be obtained with notwithstanding failure to pay, and it can be obtained with a caveat attached for the payment, so that the applicant could receive title and be able to monetize that title, to get whatever loan they may need to pay the taxes, and of course they would be able to enter into whatever arrangements as are normally permitted by tax administration for settlement of payments, of outstanding payments, Mr. President. So it is felt that the better balance would not be in regularization to waive a right, or rather waive an obligation which stands to everybody as a means of their establishing title in the first place, as part of their establishment of title, and accordingly that proposal has not been taken on board. Mr. President, the issue of public awareness was also raised, so we just give the assurance that systematic registration will be accompanied by a robust public awareness campaign to bring the NLA program to the attention of all potential owners. So the campaign is not only going to be conducted locally or in communities, Mr. President, but it will also be done throughout the diaspora, where persons may have left family land to which they have simply just not asserted a right because it is too costly, too much of a headache, too lengthy. But now, knowing that there's a new process that may be engaged more effectively, would be willing, and they may wish to make inquiries to ensure their rights are protected as well. So there will be, there will, in addition to the public awareness campaign, extensive work carried out to ensure that all potential interests are ascertained, and then the adjudication record, which will comprise a detailed list of all persons claiming an interest in the land, and the preliminary cadastral map. Those will be displayed for 30 days to ensure that all objections can be heard. And in this display, we mean not only publication in both daily newspapers, but they will be posted in all government buildings in the relevant space, the community spaces, and it will also be published on the NLA website, so that persons who both abroad and locally can have access to that document. So, Mr. President, I'm hoping that the relevant clarifications have been made and that the approach has been put forward. And just to summarize how important these two bills are, Mr. President, when they will have been passed, we will ensure that administrative processes are simplified and the requirements reduced to allow legitimate claimants to get quicker access to their titles. The rationalizing, Mr. President, is also reducing the cost of the process to obtain titles. Mr. President, the new process is going to ensure that community knowledge comes to the play, again, assisting family land that has been unmonetized for generations to to be unlocked for wealth creation. And Mr. President, as referred to earlier, the requirement to pay taxes before you can apply for title or before you can obtain title is also being removed. Again, one of the major hurdles or one of the major ways to break the cycle of intergenerational poverty or failure to monetize land, that is going to be addressed. And Mr. President, another one of the major accomplishments here will be the ability to nominate the name in whom the land which you're applying to register will go into, so that you don't have to pay additional transfer taxes. If you know you're applying for the land, but you know that it's going to go to the niece, the granddaughter, or whatever, you don't have to do it in your name and then transfer. You can nominate under this process. And again, that reduces the cost and the transaction time and the simplicity of the process, Mr. President. So with these accomplishments, with these achievements, Mr. President, under these two laws, persons will be able to unlock family wealth. And by doing so, the entire community, the entire family, community, and country will benefit. In this context, Mr. President, I ask that the bills be read a second time.
Thank you very much, Minister. The question is that the bills referred to as the STA and RTA be read for a second time. Those in favor? Against?
A bill entitled An Act to Amend the Registration of Titles, Cadastral Mapping, and Tenure Clarification Special Provisions Act, and for connected matters read a second time. A bill entitled An Act to Amend the Registration of Titles Act for connected matters read a second time.
Thank you, Madam Clerk. The Senate will now resolve itself into a committee of the whole Senate to consider the bills clause by clause. I don't know what has happened to me today. My body is here with you, but my mind is on the other side of town. So that I am referring first of all to the STA. Thank you. So there's no amendment to clauses 1, 2, 3, or 4. Yes. So there are no amendments to 1, 2, 3, or 4. So with the agreement of the Senate, I'll take those clauses first. All in favor? Against? Ayes have it. There is an amendment to clause 5, which is contained on the relevant sheet, so that I take it that they have been read, so that I would put, first of all, the amendment to clause 5. Those in favor? Against? Ayes have it. And I put clause 5 as amended. Those in favor? Against? Ayes have it.
Mr. President, we're at clause 7C. Are we at clause 7C now? Clause 7, sorry.
We're at clause 6.
Oh, please forgive me, sir. It's actually clause 5. I wanted to, it's a clarification I'm seeking, so if you could recommit clause 5, I just need a quick clarification.
You want to recommit the clause, please, or the amendment?
The clause.
Okay, the question is that clause 5 be recommitted. In favor? Against? Yes, Senator.
Thank you, Minister. Mr. President. Minister, I asked a question at 7C1. It speaks to the declaration the CEO of the NLA will recommend, and the minister may declare any parcel of land in a project area. And I wanted to find out if the project area referenced here is a project area that would have been declared under what used to be LAMP. I just need a clarification. Yeah, okay. So within the project area, then you declare somewhere for the systemic registration. Thank you, Minister. Thank you, Minister. Thank you, Mr. President.
Thank you. With that clarification, I put clause 5. Those in favor? Aye. Against? Ayes have it. Clause 6, there is no amendment, and I put it. Those in favor? Aye. Against? The ayes have it. There is an amendment to clause 7, which is contained on the amendment sheet, and I would put, first of all, the amendment to clause 7. Those in favor? Aye. Against? Ayes have it. So I put clause 7 as amended. Those in favor? Aye. Against? There is no amendment to clause 8, which I put. Those in favor? Aye. Against? Ayes have it. There is an amendment to clause 9, which is to be found on the relevant amendment sheet, so that I would put.
Before you put clause 9, Mr. President, I hear the minister based on instructions of the technical team, but I am trying to understand the rationale, and I'm looking at all of clause 9 now, 9A1, little 1, and 9C. I am trying to understand the rationale for the property going to Crown land. That's one. Secondly, at 9C, it speaks to the property being held on trust for 20 years, and then after 20 years, if no one claims, then it is deemed bona vacantia. I wondered, Minister, and perhaps you could ask the technical team to provide some guidance, whether during this period, because clearly it's not going to be changed, so during this period that it has been held on trust, which rule applies? Is it the adverse possession rules of private property, 12 years, or is it the adverse possession rules of 60 years Crown land that applies if somebody wants to then possess the land? So one is a clarification. Well, one is to get an understanding as to why Crown land. You know, maybe I'm a little slow, but I didn't hear the reason behind it. And the second one is I'm seeking a clarification as to what happens under 9C when the property is held on trust for the Crown. Which rule of I'm calling it adverse possession, but using the term adverse possession loosely, but which rule would apply for a possessory tie? So is it the 12-year rule or the 60-year rule during that trust period?
Mr. President, I'm going to ask, while the technical team, they're saying it's 12. It's a 12-year rule that would apply. Yes, and if they want to pen something for me in respect of the policy behind the bona vacantia, the policy behind, the reason behind, not how it operates, but the policy behind. That's what's being asked.
Yes, thank you, Minister.
Right.
You've understood. Thank you so much.
So then, but if we could perhaps proceed to the next while that is highlighted, and we could come back to it. That way we could continue.
Thank you. So we'll return to clause 9. There is no amendment to clause 10, which I put. Those in, I beg your pardon?
Sir, Chairman.
Sorry, Senator Sinclair. Minister, you're saying something to me? Is that comes up before, right? Yes, okay, there's a renumbering. Sorry, we're back to 9?
Sorry, yes, sir.
Okay, so Minister, let us just finish with 9 because you've been asked another question on 9. So the technical people can work.
I hope this is
and sorry, Senator Fraser-Binns. Senator Sinclair was before you. May I just take him? Senator Sinclair?
She can go ahead.
Okay, go ahead, Senator Fraser-Binns.
Thank you, Minister.
You're not thanking me too.
Thank you, Senator. Sorry. Always thanking you. Yes, 9EC. I had recommended that the consent of the owners for the adjustment of the boundaries should be in writing. I wondered. It was accepted. Okay, great. Thank you. And at 9G, the recommendation is that we are going to delete the need for the applicant to request the reason in writing.
Thank you, Mr. President. Just on the point of bona vacantia.
Before you get there, Senator Fraser-Binns had raised an issue.
I wanted to make sure my understanding at 9G is correct, that the applicant no longer has to request a reason, but that reason will be given as a matter of route for the rejection of the application. Okay.
Minister,
yes,
sorry, before you address that, Senator Sinclair.
On 9G, I need some clarification. Where it says that the applicant, and I'll just skip the words that are not too relevant to what I'm asking, to appear before a judge to substantiate and uphold the grounds of his refusal. The principal act of the SPA does not have a definition of judge, as you would find in the Registration of Titles Act. The Registration of Titles Act has definition of a judge being limited to a judge of the Supreme Court. Under the SPA, and by virtue of the fact that I see judge in common letters, J, does that mean that the application by the applicant can be made to a parish court judge? I think it needs to be specified so that it is clear that it is a parish court judge that reference is being made to.
Will you look at whether that...
Educating me? It is not. No.
The minister is addressing it, Senator.
I want to be,
Senator Sinclair, don't be drawn into any discussion with Senator Crawford, you know. Remember, it is the uncle who is the senior lawyer, not him. I was wondering whether it should be specified.
They're going to propose an amendment where the definition of judge for the purposes of this will be used.
Perhaps, Minister, I wondered.
1 minute, Senator Fraser-Binns. Is that going to be in the definition section, or are you going to just define it in the...
Just for Hansard to hear, so the guidance is that the policy is to ensure the broadest access to justice. So whether you're before a parish court or whether you prefer to take it with a broader jurisdiction under the Supreme Court, then you could do either. So in those circumstances, do you still believe that there should be a definition that...
It has to be made,
I
to me,
want
I'm asking.
to me,
asking what
I
you're
think
intending.
it has to be clear to state that reference to judge also includes a parish court judge.
Right.
I
Mr.
think
President,
so. It needs to be made clear. And quickly, the other point.
while I still on that point, though,
Don't leave
Sinclair,
it. Don't
Yes,
leave it
that's-
until we have clarified it. So it
So that's
would
being
read to a judge of
accepted.
the parish court or the Supreme Court.
They
So
will
it-
propose an amendment to
Yes.
address the
Mr.
policy
President,
concern you raised.
on that specific point, Sinclair, before you move on, Senator, before you move on to your other point, are you still talking about the judge? Right, I have something specifically about the judge. I wondered, and maybe the technical team can provide some guidance, but Minister, you know that there is a limit in the parish court as opposed to the Supreme Court.
Yes.
So I want to go back to the initial proposal about the parish court, because we could not limit it that way, because property over a certain value would not go to the Supreme
that's
Court.
why
Would not go to
that's
the
why
That's
it's
what I just
either.
said,
That's why it's
Senator, that
either.
the policy is to ensure the widest access to justice. So if you wish to proceed before a parish court, then you could so do. And if you wanted to go to the Supreme Court, you could also so do. So they will propose an amendment to ensure that that is clear, right? So
Thank you very much. So while the technical people work on that, Minister, you could address the issue of the policy concerning bona vacante. I think you were asked
right.
to do
The
that.
issue is that someone must hold land. Someone must hold land. Even if it is that the Administrator General is unable to identify someone who's entitled, etc., it is held as bona vacantia until such decision is taken. So the point here is that it will be held in trust, and that during that period of time, if there is another claim which is asserted, then it can be asserted. And as I had indicated earlier, that there can also be the director can also be, the decision of the director can also be reviewed. So there's no difficulty in that happening, but land must be held. So the fact that someone is unable to assert title shouldn't mean that the land has no defined holder and they simply continue to try to assert it. It will be held appropriately, and then if they then are able to assert at a later time, then they can so do.
You know, Minister, I hear, and I, to some extent, I can understand the reason, but my greatest challenge is that I don't believe that the Crown has done well with what it has, and I have no confidence at all that it is going to do any better when it gets additional land. I am very concerned about it. I cannot support this provision, I must tell you. I just have no confidence. I'm sorry, and it's not
Your
the
position
present.
is
It's not the
noted.
present.
No, that's fine.
It's something that has happened
Yes, I
over
take it. It's a
successive
principal
government.
position, but this is a policy, and it will not be amended. So, yes.
Minister, you have the amendment for 9G yet?
No, it has not been put forward yet. The amendment. Right. So we could perhaps move to the next and then.
Okay, the
come
next
back if there's
area
not-
for your approval reads 9 Section 10 of the Principal Act as amended. That's relating to the renumbering, right? Okay, so those in favor? Against? There's Section 10, Clause 10. There's no amendment proposed. Those in favor? Against?
Mr. Chairman, before you move on, recommittal,
I've done
please.
already, you know. What
A
do you want?
recommittal, Mr. Chairman.
Where?
To 9HD.
So 10 we have dealt with. The question is Section 9, Clause 9B,
9HD.
9HD. Yes, go ahead.
In 9HD, it speaks to knowingly and.
Senator Sinclair, we have moved on from that, you know. We're going to come back to 9, you know. I've moved on to 10.
Appreciate that.
We didn't finish 9 yet, you know.
Okay, all right.
We can hear it, Mr. President.
All right, so let him
can
raise a
work on
new
it by
issue.
the time.
Raise a new issue after I put 11, to which there is no amendment. Those in favor? Against? The ayes have it. Senator, raise your new issue for 9, please.
In 9HD, where it speaks to knowingly and corruptly gives false evidence, why was there the need to add and corruptly, which has a different meaning?
Raises the threshold for proof, doesn't it?
Yes, that is what I'm saying. So, and then when you compare it to the other things in the same,
Yes.
Look here.
just take out the and corruptly.
Knowingly makes a false
Because,
declaration.
I think it is stronger than just knowingly. You have to show that it is done with some evil intent. Huh? Yeah, no.
Okay, thank you, Mr. President. It would be aligned. The intention is not to make the threshold so high that you're unable to enforce. So we will delete and corruptly, because the issue is that you knowingly give false evidence. Yes. Knowingly give false evidence. How are you going to prove corruptly? It's a higher threshold. If you are able to prove that the person reasonably ought to have known, or you're able to prove that the person knew or ought to have known, then you're able to prove that they. How do you prove corruptly?
Mr. President. But I think that they were trying to capture negative intent outside of just knowledge, that you were intending to create some negative outcome, more so than just know. Because I might reasonably should have known, but when all right, first of all, I've read before that even language is a difficulty with some people in court. When the lawyers speak, for example, a person may not even properly understand what was being asked of them. Later down you say, okay, he should have known, and then he's guilty without intent to corrupt or intent to mislead or intent to. So there should be some intent to mislead at least.
You knowingly give false evidence. That is where the intent lies. You know, it's not that you don't know that you're giving false evidence. It is that you knowingly give it. That's the offense. That's where the intent is caught.
Okay, so it's not the.
If you don't know, then that's an error. If you know and you give it knowingly, that is the intent. That is the malintent. Yeah?
Mr. President, I may.
Sorry.
Floyd?
Senator Morris.
Yes, Mr. Chair. Minister, and corruptly, because I'm having an issue with removing that there, because I am understanding it to be that if it is that an individual knowingly gives false information and at the same time engage in, for example, an act of bribery to give that false information, that is where the and corruptly would come in.
Mr. Chairman and Senator Morris, members.
Let me just. You see, the problem is Senator Sinclair. If you put knowingly and corruptly, then you have to prove two things.
Two things.
Knowledge and corruption.
Right.
So you have a problem.
And if you go through 9HA, it says knowingly makes any false statement or declaration. 9C, knowingly makes a false declaration. Why don't put knowingly and corruptly for all of them then? You maintain inconsistency.
Can You would make it impossible.
Why are you going to put it at a higher
You would make
burden?
it impossible. It is that if people are knowingly making false declarations or giving false evidence, that's what you want to capture. To try to figure out whatever difficulties around corruption, that will make it difficult to enforce. So let's keep it simple and take the suggestion that has been made.
I have to support the retention of just knowingly, because that in itself communicates the mens rea of, which satisfies the requirement in criminal law that you did something with intent. To say that it is corrupt because you don't have to reward the person for giving that false statement. They might be motivated by other reasons apart from a gift, a bribe, or anything like that. But so I think that it captures the whole purpose of the criminal law if you keep it at knowingly, knowing that you have engaged your mens rea. You're doing it conscious of the fact that it is false and wrong. That's my view.
Yes, Senator Scaffery, you had a question.
Intent. What ill did you want to correct by having it here? And secondly, you don't have to have an intent. It can be per incurium, you know. And secondly, in the whole business of land titling and ownership, we know the corrupt acts can take place with documentation and so on. So where in this bill would capture that, or that would take the normal course of the law? Would that satisfy when person false document, person forged a signature and so on? That happens also in the whole titling. And so let's be clear about that for family members. So I just want to be clear.
Fraud is captured in E.
Okay.
Fraudulent aspects are captured in E.
So I just want to be clear that all the aspect of potential corrupt activities, that the bill is still capable of dealing with it decisively, because we know the realities out there, especially when it comes to generational type land, where a big brother forged a document and so on.
They are captured, Senator.
Madam,
the concern is justified, and they are captured.
Chairman.
Our small brother.
Chairman, the word corruptly.
Yeah, go ahead, Senator.
Yeah. Word corruptly is only used in this clause, a point Senator Sinclair made. But this exercise at 9HD is one in which somebody is likely to be under interrogation. And I'm thinking about, we know on the international scene, for example, the Flynn case. Is it just a material falsehood? Some comment that is false and the person might have known. Is that enough under interrogation? Because questions may be misunderstood as well. And it strikes me that the corruptly is a protection there to make sure an aggressive interrogator, you may find that to be so too. But an aggressive interrogator doesn't get a falsehood and then go and prosecute that falsehood when it is not, was intended to be corrupt. And I think that's probably why
Senator Crawford, thank you for taking us down this rabbit hole here. Sorry? Thank you for taking us down this rabbit hole.
No, it's not. No, I'm not going down a rabbit. I don't. Yeah, but.
I understand exactly what you're saying, Senator Brown. No doubt the minister will address it. Because there is silence, and the fact that the minister is taking instruction don't mean that somebody have to say something else. No, you can't do that because it's two different standard of proof you deal. Because then you could have a situation where a judge says, I find that this was knowingly, howsoever it is corrupt. And then you have a problem. So you have to stick with the standard of proof, which is the higher level of standard of proof of the two. Thank you very much. So there is an amendment. The amendment proposed, which we will take eventually, is to remove the word "and corruptly." And Minister has an amendment to 9G. Yes.
9HD, we're deleting the words "and corruptly" in the last line of 9HD. And if we go back to 9G, Mr. President, where the concern was raised regarding the judge and the interpretation of the judge, what we will be doing, Mr. President, is renumbering 9G to create 9G1. The paragraph which is currently 9G will now be renumbered as 9G1. And we will insert a 9G2, and subsection 2, 9G2 will now read, in subsection 1, reference to a judge means a judge of the Supreme Court or a judge of the parish court. That way both jurisdictions are available and access is preserved, as is the policy.
Thank you. Thank you very much. Minister, would you just reread the amendment for me, please?
Yes, Mr. President.
9G2.
9G, we have renumbered 9G as 9G1. And 9G, and created subsection 2, which reads, in subsection 1, reference to a judge means a judge of the Supreme Court or judge of the parish court.
Thank you very much. So there are essentially three sets of amendments. The first set of amendments are on the amendment sheet to section 9, and I put those. Those in favor? Against?
Mr. President.
Divide.
I'm dividing on clause 9.
So do I have to put the whole clause?
Just to indicate,
as to how you treated it, because there are some sections that I really do support, but there are two particular sections that I cannot support.
All right, I'm going to have a divide in relation to the amendments, no, sir?
No, Mr. President.
It's to the clause itself. So hold on a minute. Let me put the two amendments. So I have the amendment sheet. Those in favor with the amendment sheet? Against? Those in favor? Against? Ayes have it. Now there is an amendment to 9HD, which removes the word two words, and corruptions. That's correct? And corruptly. Those in favor? Against? Ayes have it. And then now there is an amendment to 9G, which renumbers 9G as 9G1 and creates a new 9G2, which reads, Madam,
in subsection 1, reference to a judge means judge of the Supreme Court or judge of the parish court.
Well, you have heard the amendment. Those in favor? Against? Ayes have it. Now this is where you are going to come in, Senator Fraser-Vince, because I'm putting section 9 as amended. Those in favor? Against? Those in favor? Against? Yes. So you vote no and you want to divide.
Let me just say, and I'm seeking your guidance whether it should be a divide or if I should just say I'm against it. I am against it.
Noted in the record.
Okay, so what I'm going to do, Mrs.
There's a waiver.
What I'm going to do.
I'm just saying, that there's a waiver of Crown Estates Act. There's even an act that deals with how it is that you contest rights of the Crown in circumstances where you feel that a right trumps that of the Crown, or it is otherwise dealt with in trust. So it's actually, this is not creating something so new as preserving a process where a new process is also being imposed. So I just leave that with you. I understand you have a deeply felt position, and I wonder whether the clerk would advise if she's simply able to note Senator Fraser-Binns' position.
You're persisting, Senator Fraser-Binns, you're persisting?
I'm satisfied with the notation. Yes, Mr. President.
No. So the record will indicate that Senator Fraser-Binns voted no. There's no. Okay, that's okay, Mrs. Cook. So the Hansard has reported, Mr. Orderly, I'm addressing the Senator. Okay, but you have made the Hansard will record your negative vote here. Okay? Abstention? All right, so you're abstaining. Okay, so here we go again. Those in favor? Against? Against? Good. So Senator Fraser-Binns has abstained. I'm not going to delay us with a divide because it wasn't called for. Okay. And I'm to put, because of the renumbering, I'm to put clause 12. Those in favor? Against? And I'm to put clause 13. Those clauses are there, but were renumbered. Those in favor? Against? Okay. I put the schedule. There is an amendment to the schedule on the sheet. So I put the amendment to the schedule. Those in favor? Against? Ayes have it. I put the schedule as amended. Those in favor? Against? Ayes have it. And I put the title and enacting clause. Those in favor? Against? Ayes have it. Thank you very much, members. And I go to the Registration of Titles Act. There is an accompanying amendment sheet, and the first amendment appears at clause 4. So with your agreement, I will put clauses 1, 2, and 3. Those in favor? Against? Ayes have it. There is an amendment to clause number 4, which amendment is contained on the amendment sheet. And there is an amendment to the amendment, because at the amendment sheet 4D, it reads, proof of payment of property tax after notice of the application advertised in the newspaper in wide circulation in Jamaica. So I put the amendment to
President, Gordon. President clearly want the articles to be a newspaper in wide circulation.
Okay, so let me read it again then. Maybe I never read it properly. Proof of payment of property tax after notice of the application is advertised in the newspaper in wide circulation in Jamaica?
Yeah, so
Or
my proposal is that we...
Thank you, Senator
That
Brown.
will read more clearly.
So I put the amendment to the amendment, which now reads, proof of payment of property tax after notice of application is advertised in a newspaper in wide circulation in Jamaica. Those in favor to the amendment Against? The ayes have it. I put the amendment as amended. Those in favor?
Aye. Mr. President, still at clause 4?
Yes, I'm about to put clause 4 now.
No, just before you put clause 4, Minister, I had made a recommendation at 28A, 1, little 2, that says where the applicant is the personal rep of the person with the COC, with a certificate of compliance. And I had recommended that we use wording similar to what is found in clause 10.2 on page 5 that says, or any person claiming through him. I believe I had given the reason for my recommendation. I wondered whether any thought was given to that.
It's not on the list, and I did not have it in my note, so allow me to just check to see whether a decision was taken and it was inadvertently left, or it can otherwise be explained.
Is that Senator Williams around the back? Yeah? Nice to see you. What's the section, Senator Fraser-Binns? Come again?
1,
Okay.
little 2 on page 2, sir.
All right, thanks very much. And yes, so the proposal has been accepted, and so the intention is to ensure, or rather is to place in 28A1A, after certificate of compliance and the semicolon, you would come back to the margin of A to say, or, and let me just make sure, or any person claiming through him, so that both 1 and 2 will be qualified.
You have heard the amendment? Madam Clerk, you got that?
So it's back to the margin.
Ms. Curtis, you got that? Okay.
Okay.
What's that, Ms. Curtis? Okay. So you have heard the amendment to 4. And those in favor? Aye. Against? Ayes have it. Thank you very much. There are no, the next amendment appears on.
Clause 5, didn't you put clause 4, sir?
Yes, I'm sorry. Thank you. So I put clause 4 as amended. Those in favor? Aye. Against? Ayes have it. The next amendment on the sheet appears at 11.
Before we go to 11, sir, could I just
Okay.
raise clause 5? Minister, I wondered, I hear
What clause you
clause
dealing with?
5, sir.
Okay. So I'll put it individual. I put clause 5. Member, you want to say something?
Thank you, Mr. President, Mr. Chairman. Minister, I heard what you said about the property tax. The challenge, I'm not going to belabor the point, but the challenge we face is that a lot of persons live on a piece of land, and so whereas they go and they pay the tax for that little piece, they pay $1,000. The property tax would probably be $3,000. They would pay $1,000, and they still have the problem finding the additional funds. That is a concern I have. I hear what you're saying about the reason why you're not minded at this time to change based on the recommendation made by myself and Senator Skeffrey. In light of that, I wondered, and considering that you relied on clause 3 about the power of the registrar to lodge a caveat, I wondered whether, and the technical team is there, whether it is necessary to put a term under 2, maybe 2 or and then call it 2, but something to the effect that says nothing shall prevent the registrar from issuing a title and lodging a caveat. I'm not a draft person and I can't, but the reason I'm making that suggestion, Minister, is I'm not convinced that the provision as itself and the interpretation you have given to clause 3 go hand in hand. It's not, to me, it's not a clear flow that says, so you can't afford to pay the property tax. The registrar will then decide to lodge a caveat, to issue the title and lodge a caveat. It doesn't flow like that from my reading of it. And I believe that if that is a power, and it is in fact a power given to the registrar, then there should be stated somewhere a process that allows the registrar to exercise that power. So I'm the applicant. I have done my advertisement and I'm not ready to pay my final fees, but I need to lodge my property tax. I simply can't. At what point then does the registrar say, fine, I will issue the title and lodge a caveat? Is there a process that must be invoked for that to happen? I hope you're understanding what I'm asking. From reading the legislation, I'm not seeing it, so perhaps you can explain it, and whether it would be useful to put in a proviso or some provision that gives the registrar, that links directly to 5.2, that gives the registrar that power to issue and then lodge a caveat.
I do understand your question, so I will await some guidance as to how to give you the assurance that you seek, right?
There is no amendment until we come to...
Something at 10, Chair.
Okay, let me just go through then. So I put clause 6. Those in favor? Against? I put clause 7.
Those in favor? It's not an amendment. Let me make it clear that I'm asking. I just want to find out if we can get some assistance from the technical persons. In 7.2, on page 5, where the registrar shall cancel any existing certificate of title and reissue a new certificate in accordance with Cadastral plan where boundaries have been acquiesced under the subsection 45.2 of Limitation of Actions Act. That section of the Limitation of Actions Act, if my memory serves me correct, gives to a person a defense if there's a boundary dispute and somebody sues for trespass. Can say, well, these boundaries have been acquiesced. So it is a court that is going to make the determination after hearing the evidence that there has been some acquiescence. There was acquiescence.
I think, doesn't the amendment in clause 14,
Huh?
the amendment to section 45 of the Limitations Act, the amendment that's set out in clause 14, that doesn't address...
Sorry, in 14?
Yeah. Where it speaks to the operation of of acquiescence.
The bond shall be deemed to be notwithstanding any enactment, provided the parties affected do not object to this, to same. So, what I'm just trying to find out, because I don't think that has given me the answer. If a boundary exists and I am seeking to amend my title by this provision, my amendment of my title, can I do it alone to say, well, the person, this boundary has existed for 12 years? How is that acquiescence established for the registrar to then act on it? So there would have to be a process. So it is. I got you. All right.
Surveyor will be going out to do the survey and have to serve notice under the Surveyors Act, and so there would be an opportunity.
So there will be some notice. All right.
Yeah.
Reason. All right. Thank you.
That's my thinking.
Thank you very much, members.
That is in practice what it would be.
Thank you very much, members.
Thank you very much, Senator Sofa Fraser.
So I put clause 7. I put clause 7. Those in favor? Against? I put clause 8. Those in favor? Against? I put clause 9. Those in favor? Against? Clause 10. Senator Scott Martin, you had something?
Wanted us to take a look at 10.4. I'm not happy with the wording. It says where any of the balance of the purchase money is outstanding as a result of an agreement in the memorandum of sale, such amount shall be retained. I think we should insert that such amount be retained. And then when we go on to then proof of that amount shall not be required to be submitted, I think we should be consistent with the previous clause, which refers to proof of payment of such money, and put then proof of payment of that amount, because I think that's the intention. So if we put then proof of payment of that amount, in other words, what it seeks to is that once you exhibit the memorandum of sale and it says, balance on so and so, then what the registrar is being empowered to do is to say, because it is by virtue of agreement, that you wouldn't have to prove that you have paid the money, right? Yeah. But it just needs a little you understand, Minister? So we're going to say, where any balance of the purchase money is outstanding as a result of an agreement in the memorandum of sale, that we're going to insert that. Yeah. That such amount shall be retained. And then we're going to put then proof of payment of that amount.
If I may, I think I support your position, Senator Scott Motley, because
clarify whether the intent was in fact to address the amount and not the payment. So
it has to be if you look at 10.2, they said the receipt which is issued by the accountant, you have to put it into the accountant general, pay it into the accountant general, and then the receipt shall be proof of payment of such monies. What that section seeks to do is to distinguish where the agreement says like balance on completion or something like that. And it is saying that the registrar doesn't need any proof of payment of that money because specifically the agreement makes provision for that. That is my understanding. If I'm wrong, I would seek the clarification.
And I think the reason why I think that's important.
President, 1 minute. Go ahead, Minister. I think you have an acquiescence.
Yes, the proposal has been agreed to, so we need not delay on the point. So we will include the word that before such an amount shall be retained. And this, for the purpose of Hansard, is on page 6. So we are in clause 10, sub 4, in the last line, second to last line, after memorandum of sale, insert the word that. So it will read that such amount shall be retained. And then the sentence will continue. Then proof of payment of that amount shall not be required to be submitted. So both amendments have been accepted, Mr. President.
Thank you very much, Minister, and thank you, Senator Scott Motley. Those in favor of the amendment? Aye. Against? I put now clause 10 as amended. Those in favor? Against? Ayes have it. There's an amendment on the amendment sheet in relation to clause 11, and I put that amendment. Those in favor? Against? Ayes have it. I put clauses 12, 13, and 14, to which no amendment has been proposed. Those in favor? Against? Ayes have it. Can I return to clause 5, where
Chair,
there is a proposed amendment?
could I urge a recommittal of 4D, where we made the amendment in respect to a newspaper? If we agree, I'm doing this as a proxy for one of us who is not here, but who, subject to the resolution to come later, is participating remotely. So the suggestion, President, at 4D.
Okay, hang on. So the first question is whether we are prepared to accept the recommittal of 4. Those in favor? Again, Senator Brown, what is it that you...
Yeah, I'm being a proxy. The suggestion is that a daily newspaper, whereas we said a newspaper, a daily newspaper in wide circulation. Otherwise, you may get in struggle or one of those papers. Yeah, a daily.
Yeah, we don't have any objection to that. What is the newspaper? You might get it in struggle or a bang. I don't know if anybody except me and you know about a bang. I noticed that Senator Samuda was totally unfazed with the word a bang. I don't know a bang. Senator Brown was the associate editor of the bang.
But our colleague who is not here.
There is a proposed amendment to a daily newspaper. Those in favor? Against? Curtis, Ms. Curtis, you have that?
For the purposes of Hansard and the Deputy Clerk, on the amendment list in respect of the RTA, yes, and in respect of clause 4. So this is now, yes, so in the amendment column, paragraph 2D, which starts proof of payment, yes, after the word advertised in, we would insert the word a daily before newspaper, a daily.
Thank you very much. So you have heard the amendment and you have accepted the amendment. Those in favor of 4 as amended? Aye. Ayes have it. Yes, back to 5, Minister.
Yes, Mr. President. The issue, the final issue which is outstanding, Mr. President, is the matter of possession and taxes. And the guidance given is essentially, as had been stated earlier, possession is integral to the establishment of an interest in land. And the payment of property tax is an obligation imposed on the occupier or a person in possession. The two are inextricably intertwined, and this is widely provided for under law, under the Land Valuation Act, under the Property Tax Act, but the utility here is that the SPA is providing for the facilitation of titles notwithstanding. So there is an administrative process which will take care of the question that you're asking, which is, and this is the point, the Senator was asking, at what point does the registrar make it clear that she will issue title with the caveat attached, as opposed to, given how it is phrased in clause 3 versus in versus clause 5. There's no direct link between the two clauses. So the Senator was asking, what legislatively, or do we need legislatively something to connect the two? So if it happens, if it occurs otherwise, if that is provided for otherwise, which it may well be, I think what we would appreciate is an assurance of that, or clarification of that.
Now we are in the highest court of the land, adjudicated by the highest judge in the land.
Mr. President, we have addressed all other issues. This is the final outstanding issue for the bill? Okay, let's be clear.
Thank you, Minister.
All right, Mr. President, I do have a clarification or guidance to give on this particular point. So under clause 3, this is where the caveat is lodged in respect of applications under the SPA. So it refers to 28A1B. This is the power. Requires nothing further. It attaches here. It's not mandating it to occur in every circumstance, but it now can apply to applications under the SPA, as opposed to now under the existing law where you must pay it up front to apply. So it is taking us significantly further. Under clause, under 5, sorry, sub 5, 10.5, the question asked before, no, it's in 5, sorry, 5C. That is in respect of applications outside of the SPA, regular applications. So you must, if you're seeking to transfer under regular circumstances, you must be able to prove payment of taxes. That is not changing. And that caveat in respect of that's unrelated to the benefits that are now accruing under the SPA. So the two will not be linked because they are actually separate operations, separate processes, separate powers.
Please forgive me, sir. So clause 5 doesn't have anything to do with the SPA. It deals with Kingston and St. Andrew, because really Kingston and St. Andrew are the only parishes that do not have SPA. Yes? That's what we're saying.
We're not saying it only applies to Kingston and St. Andrew. What it is that 5 has nothing to do with the SPA. It is outside of it.
Right.
It's your regular transactions that take place under the RTA, not related to the SPA. Just.
But so it deals with Kingston and St. Andrew because those are the only two areas that have not been declared under the SPA. So clause 5 and Portmore would.
Okay.
Right.
Thank you.
No, I don't think I understand, but I don't want to detain. Maybe we can have a discussion later, but I still...
Yeah, that's a
We
good
can
idea.
discuss it further, but,
Yeah.
but they're satisfied that it is as it should be. There's no connection between the two, and that under 3, this is the power, the actual power of the registrar to issue the caveat in respect of property taxes unpaid, where an application has been made under the SPA. So this is now where title is being facilitated. A caveat can be issued. You no longer have to pay your taxes upfront in order to apply. That is the benefit here under this amendment.
Okay, and so my second question, so someone who is applying outside of the SPA and needs to rely on that provision, is there a process? Do they write to the registrar and ask, is there a process for the registrar to invoke that power?
No, this is about the SPA. This amendment is about the SPA. It's about applications that are being made under 28A1B.
Clause 5 does not relate to the SPA at all. That's what I'm told. It does not relate to SPA. It relates to regular applications, for example, say in Portmore, which is not the SPA area.
Yes.
So I'm asking for an applicant in Portmore, an applicant from Portmore, whether is there a process for that person to benefit from this provision?
Minister, it's okay.
Yes, but I need to understand now because I've been confused.
I understand what you're saying, but it does not... because what there's...
Thank you very much, Senator Fraser-Binns. Thank you very much, Minister. So I can now put clause
Yes,
5.
Mr.
Those in
President.
favor? Against? The ayes have it. I put the title and enacting clause. Those in favor? Against? The ayes have it. The question is, I do report the registration of titles, cadastral mapping and tenure clarification, Special Provision Amendment Act 2020 as having passed committee stage with 12 amendments. And I further report the Registration of Titles Amendment Act 2020 as having passed committee stage with 4 amendments. Those in favor? Against? The ayes have it. Okay. I do report the registration of titles, cadastral mapping and tenure clarification, Special Provision Amendment Act 2020 as having passed committee stage with 12 amendments, and the registration of titles Amendment Act 2020 as having passed committee stage with 4 amendments. Minister?
Thank you, Mr. President. Might the bill be read a third time?
Just repeat that, please.
Might the bill be read a third? The bills be read a third time?
Thank you very much, Minister. The question is that the bills be read a third time. Those in favor? Against?
A bill entitled An Act to Amend the Registration of Titles Act and for Connected Matters, read a third time and passed. A bill entitled An Act to Amend the Registration of Titles, Cadastral Mapping and Tenure Clarification, Special Provisions Act and for Connected Matters, passed with 12 amendments. Read a third time and passed.
Thank you very much. Senator Gale. Those in favor? Against?
Mr. President, Mr. President, I have the responsibility this afternoon to, it is a trade union, to provide a special report of the Standing Orders Committee of the Senate regarding the proposed amendments to the Standing Orders to empower committees to hold virtual sittings. And Mr. President, I want to start on the context that one of the ways...
Sorry, Senator Gill. Ladies and gentlemen, if you're leaving now, you could do so. And thank you very much for your assistance this morning. Thank you. Yes, Senator Gill. Sorry to have interrupted.
Thank you, sir. As I was saying, one of the ways for us to ensure that a strategic objective can work is to test it. And based on the demand that was placed upon us and the awesome responsibility, was that a motion on the April 24th, 2020 was approved by the Honourable Senate to empower committees of the Senate to meet virtually in circumstances specified. And I just want to remind ourselves of the motion. It says, whereas the public health emergency arising from COVID-19 pandemic has resulted in the promulgation of legislative measures to limit public gatherings and the movement of persons during the period of emergency. And whereas the legislation provides for continuity in the work of Parliament by means of exemptions for its members and staff. And whereas, notwithstanding the exemptions, it is desirable to remove any risk associated with conventional meetings while encouraging compliance with the restrictions among the population. And it went on, sir, that be it resolved that the Committee of the Honourable Senate be empowered to conduct their business using available information, communication technologies that enabled virtual meetings to be held via the World Wide Web. That, sir, was an awesome responsibility. And we never knew when we started what could have happened. And I want to commend yourself as chairman of the committee and Senator Floyd Morris for the concept and the approach. I think it...
Will you repeat that for the members who might have missed?
Yes, they might have been distracted. That it was an awesome responsibility entrusted on the committee with the vision of both yourself and Senator Floyd Morris. So, President, it required a revolutionary change based on the unique situation. But I want to say that these meetings were essentially progressive because members, they started on time. They started on time. And the volume of discussions that took place was immense. We got through quite a lot. The committee, sir, we met on May 7th, 8th, and 14th, and the committee welcomed the approval given by the Senate to empower us to meet virtually. And one of the things this took into consideration is, outside of the cause of this disruptive pandemic, it also creates an opportunity in the event of any other emergency that may come up, in the event of natural disasters, that or any other issue that would give rise to the Senate and Senate committees being able to meet in a hybrid fashion. And when I say hybrid fashion, it took into consideration us meeting in a physical space by supporting the addition of those who cannot meet for varying reasons. And today, and the last number of sittings, we have had the absence of Senator Knight. But Senator Knight has been an instrumental, integral part of these discussions. And whilst we were not able to see him virtually because of his reasons, he has participated well in those sittings. The committee, sir, felt that members who joined virtually should have the same rights and privileges that are accorded to members of a committee, inclusive of voting rights, which is a very key part of the deliberations. Further, the members were of the view that the participation in these meetings of key persons, other than the members of a committee who are granted access to join virtually, should be limited to those who are duly authorized by the chairman of the respective committees. What that is suggesting is that, President, there may be resource persons, including staff, who needs to participate in these sittings in a way to ensure that the sittings achieve their objectives. And so the committee took those matters into consideration in seeking to craft what I'd like to outline as the amendments of the procedures of the select committees that would seek to amend areas of a particular area of the standing order. And I want to deal with the paragraph of standing order number 74.8 as subparagraph now 74.8a. And this is what it's seeking to insert, sir. Insert the following subparagraph 74.8a, B, C, and D. And B should indicate the word place in subparagraph A includes a virtual space created using information and communication technologies. And C, sir, and a lot of debate was around C, the word meeting in subparagraph A and B shall include any duly convened meeting of members of a committee. And it suggests, one, a particular physical location to which we are in today. But it also includes in a virtual space, or three, in a physical space in respect of which access and participation from remote locations by members and other persons authorized by the chairman has been enabled by means of information and communication technologies. And so there was one meeting at least where a member of the media was able to attend those meetings. Now, it went further, sir, to include a D that all members participating in any meeting of a committee as defined in subparagraph C shall enjoy all the rights and privileges accorded to a member of a committee of the Senate. What that is suggesting is that if the member was not in the physical space but would have joined us virtually, things like voting rights would be accorded. Things like their own intervention could be accorded. Things like, and you know, we're meeting virtually, Mr. President, and persons were working from home. But there would have been one point of order in all of those virtual meetings, and it came from the Binns residents. But just to show you that members were afforded all privileges and rights accordingly. Mr. President, businesses today are making policies around virtual meetings because of this disruptive pandemic. And what it also suggests to us is that this Senate would have passed a piece of legislation giving rise to flexible work arrangement. This is one opportunity for us to exercise a piece of legislation that we have passed. Mr. President, in closing, sir, I want to commend the staff that supported us. The Hansard, Miss Curtis, Miss Douglas Beckford, Miss Tracy Cohen, and there was a time, Mr. President, that we never knew where we were going. But the technical person, Merrick Brown, pointed us in that direction. And I want to use the opportunity to commend him for the forthright approach. Mr. President, this is a major achievement in the utilization of technology. It's seen as an historic moment once we go through it. I want to make special mention through those meetings of your transformative mode. Yes, transformative mode, where you made it compulsory for all members attending those meetings to make comments. Sometimes some things we don't see in this physical space. And I want to say, I've seen a heightened intensity in your approach. In fact, I want to believe that you are so excited about these virtual sittings that you are the first to be on time. And for the ones that we're having in the physical space, Senator Knight was here before any of us, virtually. Mr. President, these are challenging times. It requires the exploitation of challenging approaches. And that's what we have done in embarking on this awesome responsibility. We have had some very enriched analytical discussions. And I want to commend the members of the committee for the insight, the information presented, the level of debate. And I open the debate for any other member to give an input. May it please you, Mr. President.
Senator Brown, I need to tell you that when I was complimented earlier for allowing everybody to talk,
You didn't
One
mean
member
me.
said it was because you weren't a member of the committee, but that's not true.
Mr. President, the report has been signed by almost all the members of the opposition, and I'm sure if Senator Knight was present. Huh?
Senator
Oh,
Knight,
he has
had
given.
instructed it.
So, in other words, the opposition members are at one. I also want to agree with all Senator Gill has said. When the issue came up first, I pointed out the danger, the risk involved in meetings of the nature, virtual meetings. Just a couple days ago, a report came out, South African Parliament video call act with pornography. We are lucky ours didn't suffer that fate, and I'm sure the technical people have put in place. You're not been so unlucky. So I raise it because while it's a way to go in these crises, there are risks we run. In the case of South Africa, it wasn't pornography alone, it was sexual insults and racial insults. But they are locked down in South Africa and their parliament is trying to meet virtually. So I commend you. One of the reasons why I support the motion, Mr. President, is that there's a term we use, but for the grace of God goes I. I could have been traveling and coming back into the country in a disaster and have to face a quarantine situation. I may quarrel about the food. I may quarrel about everything. But I'd hope that the Wi-Fi facility would be there so that I can participate and we don't get into a situation where we don't ban Wi-Fi facility for people who are in quarantine, because the things they put out on social media, like the quality of meals and so forth, would not affect. So as a member of the parliament, as a senator, if I was in quarantine, I could participate. This is the point I'm making. Despite the other drawbacks that may be associated with it. I also understand, Mr. President, that if my family pull me on a cruise line in a disaster, I would be able to participate from that cruise liner, even if I'm excluded from re-entering in the country. So we're doing this for us as parliamentarians. I hope we go beyond this motion and do the same thing for the people, the citizens of the country, whether in quarantine or cruise ship or wherever. But I commend this, and I'm happy that the minister, and I hope when she makes her report on the re-entry, it will take into account people like us who sit in this chamber to say a facility like this motion would be there for us. And so as we support this for us, my heart bleeds, Mr. President, for the 1,000 Jamaicans on a cruise ship coming in on Sunday and who have been on quarantine for several periods of 14 days on different ships. And I hope at some point we'll be able to give to them, as we have done for ourselves here, the right to participate in this, the right to participate in their country's activity. Once, whether you want to have a certificate of COVID-free from the doctors or so, but my heart bleeds for what is happening to them. And I thank you, Senator Samuda, for your apology to those people on our behalf. I thank the Minister of Health and I thank the Prime Minister for apologizing. And as we do things for ourselves, so we must do for the people who put those who appoint us here. May it please you, Mr. President, we support this.
Thank you, Senator Brown. I was sitting here wondering how you're going to manage this today, but okay. Senator.
Mr. President, Mr. President, I rise to give my fulsome support to the report that has been tabled and motion for the adoption of the amendment to the standing orders. And I concur with everything that has been said by Senator Coven Gale. And one of the things that I took note of in the committee meetings is the sense of unity and sense of purpose that members of the committee applied to resolving the particular issues that were before us. And I want to say, Mr. President, that it is a clear indication of what we can accomplish when we are united behind a particular cause. And I believe that it is something that we should make sure we transfer it from the committee to the floor of the Senate in terms of our deliberation. We understand that it's not all the time we are going to be agreeing to everything, but I enjoy every moment of those discussions. And I want to also agree with the approach in terms of the committee, Mr. Chairman, how you ensure that individuals in the committee presented and participated in a meaningful way in the discussion. And so, we have put forward these measures, members, that we believe will help to solve the particular mischief that we have to deal with in these challenging times. Today, it might be COVID. We don't know what it will be next year. But what history will record is that this Senate adopted a set of measures that will ensure that the business of the country carries on irrespective of what might be happening at the particular time. And I am very much pleased with what we have brought to the Senate, and it is to indicate that some serious work is being done in the Standing Orders Committee. And I am very much pleased with the amendments to the Standing Orders, and want to urge members to adopt those measures. And of course, Mr. President, I would be extremely delighted, because I am one individual who has to depend on the technology for my work. And, this is an enabler. And I want to commend the Senate for leading the way to putting in place measures to ensure that committees can function irrespective of the situation that confronts us. And we have another challenge that we are working with, members, and we will come to you in short order with a solution to be adopted. May it please you, Mr. President.
I want to thank colleagues Brown and Morris for their contribution. just to say that there is still more work to be done by the committee, because we also, Mr. President, have to seek some advice on constitutional changes that should be made in order to allow the Senate to meet in this fashion. The concern was also raised about the exposure to security risk. And that is something, again, that the members of the committee is going to have to review and to take recommendations as to how we would protect our exposure to any outside risk in terms of carrying out the work of the Senate through this proposed hybrid fashion. But whilst we're going on this venture, Mr. President, I just want to highlight to the Senate that notwithstanding us being afforded the opportunity to meet in this virtual fashion, the preference is still for us to meet in this physical space. And I thought I would highlight that to members of the Senate. So, sir, I want to thank my colleagues. I want to thank the entire Senate for empowering us to be able to pursue this on this venture. And with that being said, sir, I ask for the motion to be approved.
Thank you very much, Senator. Oh, yeah. I was waiting for the return of the minister. I didn't see that you have come back. You have heard the motion and the debate. Those in favor? Against? Ayes have it. Just to add that the work of the Standing Orders Committee in terms of the general review of the orders continues apace, but this was a matter that we needed to have dealt with. And I wish, as chairman, to thank all the persons who participated. In particular, I single him out because he was participating virtually at all times. Senator Knight, who is not physically with us, and of course the members of staff. Yeah, he's watching at home. The members of staff, the secretary, and Ms. Curtis, Ms. Douglas Beck for the secretary, Ms. Curtis, and Ms. Tracy Coyne, and of course our clerk, Ms. Heather Cook, who have all facilitated the very important development that took place today. So with that, Minister.
Thank you, Mr. President. It is not intended to do any further business today. It is just to add my thanks to the staff, as you have done, and to add my thanks once more for the record to the technical team, the representatives of the Registrar of Titles, the Commission of Lands, the NLA itself, and everyone who has worked on the team, MEGJC, of course, included, and all stakeholders who participated in the process to allow for the passage of the two bills which we undertook today. So, Mr. President, I thank you and ask that the Senate be adjourned for a date to be fixed.
Thank you very much. The question is that the Senate be adjourned for a date to be fixed. Those in favor? Against? This Honourable Senate now stands adjourned.
Hello, Phil. You doing your morning exercise? So all of we seniors have to keep the immune system strong.
Yes, fear. This morning I may have to remind Johnny that people 75 and over can only leave them yard to get groceries and medicine.
And you know me have diabetes, so I have to be extra careful.
Yes, fear. Elderly people who have some sickness already, like cancer and high blood pressure, they can't take no chance. They have to stay home, wash them hands regular, and don't touch them face.
And we need to stock up on medicine and supplies. We have to be ready for anything. Yes, sir. Now go finish exercise now. Keep safe, my friend.
A message from the Prime Minister of Jamaica, the Most Honourable Andrew Holness.
Under the Disaster Risk Management Act, you must wear a mask in all public access places and in public transportation. If you wear a mask and I wear a mask, we are all safer.
That was a message from the Most Honourable Andrew Holness.
It's Friday, May 15. This is the news on PBCJ. I'm Simone Absalom. As of Friday morning, there were no new cases of COVID-19 in Jamaica. The Ministry of Health and Wellness says this is the first time in 50 days that the island has recorded no new cases. The total number of cases remain at 509. Meanwhile, the number of recoveries now stands at 118 after 5 more persons were cleared by the health authorities on Thursday. There has been more than 300,000 new coronavirus-related deaths worldwide. The data comes from Johns Hopkins University. It also shows that more than 4.4 million people have been infected. It comes as a World Health Organization official warned that the virus may never go away.
There's a long way to go before there's going to be any bells unrung in this response. So I think we need to be clear about that. Countries, as you've seen, are trying to find a path out and a path towards a new normal, as many people have put it. And we're going to be on that pathway for a long time. And as we've seen in some countries, even a small recurrence of disease can cause the need for a serious response in terms of the public health response.
Prime Minister Andrew Holness has responded to concerns of returning residents regarding the less than favorable conditions in a designated state quarantine facility.
First of all, I must unreservedly apologize to every returning citizen who has had to endure less than favorable conditions. The issues encountered are completely unacceptable. I asked Minister Christopher Tufton and Minister Matthew Samuda to visit the quarantine facilities today to get a first-hand view of the situation. Arising from the visits, the government has already taken some remedial actions, and we will do everything we can to completely rectify the situation.
The Prime Minister explained the reasons for the issues.
A preliminary assessment has revealed that the situation arose from capacity issues and unforeseen circumstances such as weather and a power outage. This against a background of heightened panic and stigma.
Almost 200 Jamaicans returned this week from the United States and Canada through the country's controlled re-entry program.
The reality is that we now have over 600 persons in quarantine and isolation facilities to manage. We also have 4 quarantine areas in St. Mary and many other active contact tracing exercises ongoing. This while conducting all the other public health duties. While we are working assiduously to bring home our citizens, it is clear we cannot continue to overextend ourselves, as this increases the risk both to the general public health and our returning Jamaican citizens. We have to work within our capacity while we seek to build additional capacity. We are now beyond our quarantine capacity. It will therefore be at least 14 days before we are able to accommodate any sizable additional cohort. I have directed the ministries and agencies involved to use this period to explore ways of rapidly scaling up our capacity, both in accommodations and logistics, to ensure a positive experience for all.
The government of Jamaica has indicated that plans are being put in place to reopen the tourism sector. Prime Minister Andrew Holness spoke with CNN's Richard Quest on Thursday.
I keep telling the Jamaican people that I have two priorities. Priority number one is their health and safety, and priority number one is their livelihoods. So I don't see a trade-off between health and economy. I don't see the two things as mutually exclusive. You need healthy people to make the economy work, and a working economy gives you healthy people. So for us as a government, we're trying to ensure that we balance these two very critical objectives. And tourism plays a very important role in that, as you outline the figures. We depend heavily on tourism. Tourism is our number one foreign exchange earner, accounting for over 50% of the foreign exchange that we earn. So we have to start planning from now for the reopening and recovery.
Mr. Holness says despite the coronavirus pandemic, Jamaica will not be left behind in getting the sector back on track.
We have to plan in advance and anticipate when our largest tourism market would be ready for us. What we would want is for the United States to be ready, Canada to be ready, Europe to be ready, and we are not. So we are preparing. You know, the tourism industry is very susceptible to global shocks. And this would not be the first global shock that our tourism industry would have.
Mr. Holness says while the tourism industry is susceptible to global shock, the Caribbean region is resilient.
Part of being resilient is to plan for it. So what we're doing now is to ensure that we have the protocols. And as you have said, we are already figuring out ways how we can have controlled corridors of entry, how to move our tourists safely from airports to hotels so that they can enjoy our lovely beaches and our lovely people. We are already training our workers because that's key towards providing the kind of service that people would need in the post-COVID environment.
PBCJ had reported this week on the work being done by the Tourism Ministry on protocols to dictate how to have controlled corridors of entry and how to move tourists safely from airports to hotels. Nearly $3 billion could be axed from the national student loan budget. This as the government pivots to accommodate unplanned expenditure in this COVID-19 era. Finance Minister Dr. Nigel Clark, in tabling the first supplementary estimates for the 2020-2021 fiscal year on Tuesday in Parliament, noted that the COVID-19 pandemic is having a devastating economic impact on the world economy. Marlon Samuels has that story.
The Finance Minister told parliamentarians that despite the cut in the allocations to the SLB, the entity will still be in a position to fulfill its mandate this fiscal year.
With respect to the Student Loan Bureau, which has an $8 billion investment proceeds that are on account with financial institutions, and we provide the Student Loan Bureau with $2.9 billion a year, they have enough cash resources to finance them for this year and for the next year and still approve 100% of the applications that they receive. So just from a practical point of view, Mr. Speaker, for this year, we have to defer the transfer of the $2.9 billion to student loan, knowing that they can take care of all of their loan expenditures this year and will resume it in the following year.
He said that the government is forecasting a decline in GDP by 5.1%. Revenues are projected to decline 18% for a total of $81 billion.
Whenever we speak about any adjustment of expenditure, any deferral of expenditure that we have to absorb during this year, recall that it is in the context of a $120 billion problem that has to be addressed. And we're addressing the $120 billion problem with $70 billion of cash resources, i.e. the majority is being addressed via that means.
This is the largest portion of the $120 billion COVID-19 shock to the Jamaican economy, according to Clark. The rest of the huge bill comprises of $34 billion in COVID-19 non-debt and debt expenditure, and a net of $5 billion for the debt servicing, among other things. For the news on PBCJ, I am Marlon Samuels.
The Caribbean Examinations Council is standing by its decision to hold exams in July, despite objections from Jamaica, Barbados, Trinidad and Tobago. CXC Registrar Dr. Wayne Wesley says postponement was not an option being considered. Dr. Wesley says that the decision was made based on consultations with regional ministers of education and other stakeholders. However, he says bilateral talks can be held with countries that had objections to the date. He says countries could choose to have students sit exams in January. However, he cautioned that not all subjects are offered in January. Dr. Wesley was speaking at a press conference on Thursday. Minister with responsibility for education, Carl Samuda, had said it's not possible to hold the external exams in Jamaica in light of the challenges facing the local education sector arising from the COVID-19 pandemic. Finance Minister Dr. Nigel Clark has painted a grim picture for the country's economy in a post-COVID-19 world. Gabriel Thompson delves into that story and more in this business report.
The coronavirus pandemic is expected to cost Jamaica a whopping $120 billion. Finance Minister Dr. Nigel Clark made the revelation Wednesday in the House of Representatives as he presented a revised budget to accommodate the COVID-19 costs.
When you put it all together, Mr. Speaker, the COVID-19 pandemic has a double whammy effect. Our revenues are affected to the tune of $81 billion, i.e. revenues are projected to decline by $81 billion. And in addition to that, we have new expenditure that would not have arisen if not for the COVID-19 pandemic of $34 billion. You add those two together, you get $115 billion. And if that were not enough, Mr. Speaker, the government has what you call other inflows, which have been affected to the tune of $5 billion. You add those three quantities together, and the COVID-19 pandemic presents to the government and people of Jamaica a challenge of $120 billion, Mr. Speaker.
The finance minister explained possible adjustments to restore stability in the local economy.
This is a heavy adjustment to absorb at one time in a single fiscal year. And in addressing this adjustment, we must strike the right balance so as not to have the adjustment inordinately disturb the stability that we've enjoyed, which ultimately is a guardian for us all. If stability goes, it has a negative impact on all Jamaicans. Mr. Speaker, this $120 billion of adjustment will be achieved through two primary avenues. The first, Mr. Speaker, is a reduction in approved expenditure of $50.3 billion. And bear in mind that that's not the net reduction in expenditure because we have new expenditure of 34. So what we're talking about is that we'll have a reprioritizing of expenditure, and $50 billion worth of expenditure will be replaced by new expenditure, or in some cases would be cut.
The country's growth forecast has been revised. A 5.1% contraction in the economy is projected for this fiscal year. The International Monetary Fund, IMF, has projected a 5.6% contraction in the Jamaican economy for 2020.
With respect to Jamaica, Mr. Speaker, in my closing budget presentation in March, after we had our first few cases and started instituting necessary preemptive public health measures, I used the expression a massive economic shock to describe what Jamaica would likely experience. I gave an indication then, Mr. Speaker, that this would necessitate an early supplementary budget in this financial year as we would face new expenditure with less revenues within the context of a bleak growth outlook. Mr. Speaker, based on the information available today, the government is forecasting a GDP outturn of negative 5.1% for the 2021 fiscal year. This growth outcome, Mr. Speaker, will naturally have an impact on the government's revenues that are used to finance government expenditure.
In Thursday's trading session, the JSE Combined Index advanced by 1,968 points to close at under 400,000 units. Overall market activity resulted from trading in 80 stocks, of which 33 advanced, 32 declined, and 15 traded firm. The junior market index declined by 11 points to close at under 3,000 units. Stocks advanced for 138 Student Living Jamaica, Access Financial Services, and Barita Investments. Stocks declined for AMG Packaging and Paper Company, Caribbean Cream Limited, and Siboney Group Limited. Trading firm were 1834 Investments Limited, Carreras Limited, and Consolidated Bakers Jamaica. Trans-Jamaican Highway Limited was the volume leader with 5.6 million units, followed by Wigton Wind Farm Limited ordinary shares with 2.1 million units and Mailpack Group Limited with 1.3 million units. Now for the foreign exchange. The US dollar on Thursday, May 14, ended trading at $147.12. The Canadian dollar sold for an average $106.32. The pound sterling traded for $183.28, and the euro ended trading at $161.97. Oil prices touched a 1.5-month high on Friday amid signs demand for crude was picking up, with China reporting increased refinery runs and rounding out a week of bullish news on the supply front. Brent crude futures gained 81 cents to $31.94 a barrel. West Texas Intermediate crude futures climbed 65 cents to settle at $28.21 a barrel. And that's it for the Business Report on PBCJ. I'm Gabrielle Thompson.
Let's now join Alicia Steele for the weekly entertainment recap.
Of food, fashion, culture, and entertainment. I am Alicia, and welcome to Entertainment Recap.
As a country, we stand stronger together than divided. And 15 of our musical entertainers came together and did a song called We Are, produced by Not Nice Records. We are stronger. We indeed, as a country, can stand together through anything once we pull together.
Ding Dong is out yet with another move and another vibe. You see me? Yes, the song is titled Mirror and it have a buzz. Take a look.
So me just put on me pants and me shirt and me shoes and me touching at the streets and I go look it. If me not care, me a foot it. Anyway the vibes, me dead, me a look it. Mirror, 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 mirror on the wall. You see me? Now the body standing, the Sunday I can sing a walk around. You see me? Them a parade me thing, but them a flap because.
You see me? Mirror, mirror, ding dong, it bad. Unruly Boss Popcorn got a haircut. Yes, Unruly Boss Popcorn, king of Unruly, got a haircut. Can you imagine? The Unruly Boss cut his mane for a more sophisticated GQ look. Just look. To think the artist even compare himself to the Nick Jr. cartoon character, Little Bill. Hello, friend. Gargamel is still out here collaborating and connecting with high-profile international artists. Buju Banton and John Legend, good stuff. The song is titled Memories. Listen to it.
Treasure your body, but cherish your mind. Even though it's complicated, which is most of the time. A life without your love ain't working out fine.
Continue taking us on your musical journey, Buju. I'm here for it. For more entertainment recap, join us on PBC Jamaica YouTube and follow us on all socials at PBC Jamaica. Thanks for watching. I'm Alicia, and remember, big up you.
In regional news, former Jamaica Prime Minister Bruce Golding, who led an Organization of American States observer team to the Guyana March 2 regional and general elections, on Wednesday told the OAS Permanent Council that the poll was being rigged at the declaration of results by the Guyana Elections Commission GCOM. Mr. Golding also said that the ongoing national recount of ballots has so far showed variation in results from the ongoing recount compared to the results that were declared by Region 4 Returning Officer Claremont Mingo.
I have never seen a more transparent effort to alter the results of an election. More than a dozen copies of the statement of poll are prepared at each polling station after the ballots are counted on election night. One copy is posted on the wall outside of the polling station, and each party representative, and there were 9 in all, each party representative is entitled to receive a copy. You know, it takes an extraordinarily courageous mind to present fictitious numbers when such a sturdy paper trail exists. And this is being illustrated now as the recount proceeds. I want to give you some examples. In ballot box 4062, the statement of poll had indicated 182 votes for APNU and 43 votes for PPP Civic. The returning officer reported those results as 292 votes for APNU and 33 votes for PPP. When that box was recounted, the numbers were 182 for APNU and 43 for PPP, the exact figures that appeared on the statement of poll.
Both the ruling coalition, a Partnership for National Unity, APNU, and the main opposition, People's Progressive Party Civic, PPPC, are claiming victory for control of the 65-member National Assembly. In response to Bruce Golding's statement, the Guyana's coalition government said that his utterances were, quote, partisan, biased, and incredulous, end quote. InfoHub's Anara Khan reports.
CEO of the National COVID-19 Task Force and former Director General of the Ministry of the Presidency, Joseph Harmon, on Wednesday evening, stated that apart from it lacking credibility and leaning towards the opposition PPP, the government has noted the timing of the statement and its similarity in content and style to that of the leader of the opposition.
It would appear as if this was coordinated and pre-arranged to deliver statements which were strikingly similar in content and style.
Harmon noted that Golding's statement is not only exceptionally partisan, but it is grossly irresponsible and hostile to the nation and the people of Guyana. As a former head of state of a CARICOM nation, the government said the statement smacks of gross disrespect for a sovereign state and the ongoing process supported by CARICOM.
Golding's partisanship and unquestionable link to the People's Progressive Party compromises him, and no longer can he be considered an independent observer. He has clearly demonstrated a bias for his close associates and appears to have now become an unabashed co-conspirator of the PPP as they seek to defy the will of the Guyanese people.
The government calls on Guyanese to disregard the distant voices and pay attention to the unfolding situation.
Still in Guyana, the national recount of March 2 general and regional election results entered day 9 on Thursday. Felicia Valenzuela from InfoHub was there and filed this report.
As you rightly said, Anara, the weather today is much better, and those meetings with GCOM got underway without a glitch. The National COVID-19 Task Force did in fact meet with the GCOM earlier today, as the Commission is planning to increase its workstations.
We did have our walkthrough with the COVID team this morning. And during the course of that walkthrough, we looked at 6 possible sites. 6 possible sites. COVID is now to return the report on the feasibility of those sites. When that report is returned, then taking into consideration security advice and the availability of the relevant equipment, I think a decision will be made. So I don't see us being final on the matter before tomorrow.
In the meantime, Minister of Public Infrastructure David Patterson spoke with the media. In an invited comment, he spoke on the comments made by Mr. Bruce Golding, who led an observer mission from the Organization of American States for the March 2nd general and regional elections here in Guyana.
He is free to make those assertions, and I think he made those assertions as a private citizen. We will address specifically those actual numbers that he did raise. I think we will address it specifically. I saw them last night. I'll ensure that we address it specifically. But what Mr. Golden did not mention is the question of anomalies that have been unearthed, the question of the statistical anomalies, the questions that are in the observation report. And it's strange that Mr. Golden could right away jump to improving the integrity of Mr. Mingo and the entire GCOM staff without making even a fleeting reference to those particular issues. So yes, I do think we will address Mr. Golden's accusations more frontally right now, but I am concentrating on ensuring that the recount process goes smoothly.
Mr. Patterson said it's now for GCOM to decide what it will do with the 10 legal declarations it has in its possession.
As far as I'm aware, the GCOM has not disposed of the 10 declarations that they have in their possession. So, as I said to the young lady there, that what it is that GCOM will have them. We'll raise it with them frontally when we meet them. GCOM has to make a decision of, at the end of this process or at some point, what do they do with the 10 legal declarations that they have in their possession.
From the Artichown Conference Center with videographer Kareem Peters, Felicia Valenzuela, InfoHub.
The Bahamian island of Bimini will be placed on a 2-week lockdown beginning Monday, May 18. Prime Minister Hubert Minnis made the announcement on Thursday. ZNS Altvice Munnings reports.
The lockdown measure will be strictly enforced in order to save lives and to protect the general health of all those on Bimini.
Prime Minister, the Most Honourable Dr. Hubert Minnis announcing Thursday that a 2-week lockdown will begin in Bimini at 9 p.m. on Monday, May 18th until midnight on Saturday, May 30th. The Prime Minister said this date will be extended to 14 days when Parliament reconvenes. The decision comes after health officials confirmed 2 positive COVID-19 cases on Bimini Thursday, pushing the total count there to 13.
A total of 102 residents have been swabbed for COVID-19. Outside of New Providence, Bimini, with a population of approximately 2,000, have the largest number of recorded cases in the Bahamas. The number of confirmed cases is expected to increase if much of the population continues to fail to practice the recommendations for physical distancing, wearing protective face coverings, and frequent and thorough hand washing.
The Prime Minister released the Emergency Powers COVID-19 Bimini Lockdown Order 2020 Thursday. The document specifies that only essential workers will be allowed outside, including healthcare professionals, officers of the Royal Bahamas Police and Defense Forces, and the island administrator. The order also states that no visitor on any yacht or private boat shall be permitted to enter or disembark from Bimini during the lockdown period.
Had it not been for the weather that we're experiencing now, the lockdown would have occurred even sooner. And I ask and I urge all Biminites to initiate all disciplinary measures possible and practice social distancing even before the lockdown commences. I know that a measure like this even further disrupts daily life and economic activity. But we are now in an emergency situation.
Health officials took a proactive approach to minimizing the spread of the virus on Bimini when members of the Ministry of Health's surveillance team conducted several initiatives between April 29th and May 2nd.
The team provided educational support for medical personnel, assisted with identifying contacts of confirmed cases, visited the government quarantine facility, helped to try to enforce infection prevention and control strategies. They conducted testing and hosted a virtual town hall meeting. On that visit, 37 people were swabbed for COVID-19 and 3 tested positive.
In sports, we start off in the nets with cricket, as left-handed batsman Kieran Powell is upset over his non-selection for recent West Indies touring squads. The Antiguan believes his social background is a big contributor. The 30-year-old Powell last represented the West Indies on the 2018 tour of Bangladesh, playing the final of 3 ODIs. Powell has played 40 tests and 46 ODIs for the West Indies so far and has been left out of the provisional 30-man squad for the tour of England. And in athletics, 4 Jamaican athletes or administrators are set to benefit from a scholarship of $1.5 million each. The Jamaica Olympic Association says the scholarship program is specially designed for local athletes and sports administrators under its umbrella, with the intent of pursuing undergraduate studies but do not have the necessary financial means. The application process begins in July. And that's the news on PBCJ. Thanks so much for joining us. Remember to keep safe.
The king may rule over land and sea. The lord may live right royally. The soldier ride in pomp and pride. The sailor roam over ocean wide. But this or that, whatever befall, the farmer, he must feed them all. The writer thinks, the poet sings. The craftsman fashion wondrous things. The doctor heals, the lawyer pleads, the miner follows the precious leads. But this or that, whatever befall, the farmer, he must feed them all. The merchant, he may buy and sell, the teacher do his duty well. But men may toil through busy days, or men may stroll through pleasant ways. From king to beggar, whatever befall, the farmer, he must feed them all. The farmer's trade is one of worth. He's partner with the sky and earth. He's partner with the sun and rain, and no man loses for his gain. And men may rise, or men may fall, but the farmer, he must feed them all. God bless the man who sows the bait, who finds us milk and fruit the meat. May his purse be heavy, his heart be light, his cattle and pigs and all go right. God bless the seeds his hands let fall, for the farmer who must feed us all.
Reduce your risk of viral illnesses like the flu and coronavirus. Wash your hands frequently with soap and water. Cover your